Mr. President, as you can see, this bill relates to Section 12.1, Chapter 32 of the North Dakota Century Code, and that is the chapter that deals with penalties and sentencing in criminal cases. The bill proposes to add an additional subparagraph of options for courts. And as you can see by looking at existing law, you see all the standard things you think of penalties for crimes, including term of imprisonment, payment of fines, probation, payment of reasonable costs, all of the usual things. Subsection I, the newly proposed section, is a little bit different. It adds that a court can suspend for a period of not less than 1 year the privilege to purchase or possess game and fish hunting licenses or fishing or trapping. And you may think that's an unusual sort of penalty. It's not going to be mandated for any particular crime. It's just there as an addition to the toolbox of things that a court can sentence someone with. The primary sponsor of the bill said that he got the idea from the fact that this restriction of hunting and fishing privileges has been used for some years rather successfully in the area of child support enforcement, where if a person is behind in their child support and our state law now allows their hunting and fishing privileges to be suspended, that very idea can cause some people to promptly pay their child support. So he thought this was a good idea in this area also. We had some good discussion in the committee. Some people thought maybe it should just be mandatory, but since 70% of our population doesn't choose to hunt or fish, it would just be a lot of extra paperwork for a court to be telling Game and Fish that someone had been convicted of a crime and couldn't get a hunting or fishing license for a year. So that didn't seem like a real good idea. Others suggested that perhaps the analogy to child support was not all that strong, because child support is a continuing obligation, and therefore a person can get their hunting privileges back simply by getting current on their child support at a given time. But after a thorough discussion and a promise from the folks at Game and Fish that they would monitor this, we decided in the Natural Resources Committee by a 5-2 vote to recommend a do-pass for this. It is, as I said, just one additional tool in the toolbox, and in certain select cases it may well be a motivating factor for people whose attention cannot be gotten in any other way. So we would encourage your yes vote.
Further discussion? Senator Armstrong.
Mr. President, I rise in objection to this bill for several different reasons. One is because it's clearly dealing with misdemeanor offenses and or fishing. So I'm going to just confine my comments to hunting. One, whenever you go on supervised probation, actually whenever you go on probation, period, unless it's explicitly waived by the court under 12.13207 subsection 3, you are not allowed to possess a firearm during the term of your probation. That is obviously the case, and that cannot be waived with felony convictions. Secondly, last week I rose and talked about applying certain Fourth Amendment issues equally across the board. I would argue the same thing, and I would say the big distinction with child support and this is child support is civil in nature. This is criminal. The only way this can be applied appropriately is if you do it all the time or you do it none of the time, because primarily what you're going to do is target a specific offender or a specific defendant based on a specific hobby he has. Punishments are meant to be, we have statutory minimums, we have statutory maximums, we have various ways to do treatment, rehabilitation, certain factors that come into place. I get very, very concerned when we're targeting a punishment to a particular thing that has nothing to do with the crime committed, but has to do with the quiet enjoyment that defendant or convicted person may have on their personal time. Also, I think it's already in the statute. I don't think it's enforced properly in the statute, but every misdemeanor plea agreement I've ever written for a nonviolent offense, when I've been doing this as a defense attorney, specifically asks the court to waive the firearm condition of probation. And I should also mention firearm dangerous weapon includes bow and arrow, it includes muzzle loader, it includes all of these issues. So this isn't just a gun issue. If you're on probation and the firearm issue under current law isn't waived, if you're on 12 months probation, it's pretty hard to hunt or fish if you can't possess a firearm, a muzzle loader, a crossbow, or a bow and arrow. But just generally, principally, I mean, everything else in this subsection, A through I, is community service, day reporting, curfew, home confinement, house arrest, electronic monitoring. All of these things apply to the citizenry equally. And then you pull out hunting and fishing suspensions, and if you don't hunt or fish, this would have no ramification to you whatsoever, but you would use it particularly for a person who you know enjoys that hobby. And I just have very, very big concerns about meting out punishment in that sort of way. So I would ask for some red votes, and we reject this bill.
Further discussion? Hearing none, the question is on the final passage of House Bill 1169. Secretary, please open the key. All senators have voted. Any senator wishing to change their vote? Secretary, close the key. Final tally on House Bill 1169 reveals 10 senators voting yea, 36 senators voting nay, 1 senator absent, and not voting. The bill fails.